Alice here with part 127 of the My Docket series on child custody and visitation. As with my previous videos, I'll take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's the video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I will glaze over are, number one, not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened. And that's because my ex's parental rights have been terminated. Number two, the nutshell version as to the purpose of the series is to give my viewers one big example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. We left off in the child custody case with the actual hearing itself, and we're going now into the order after that hearing. This is going to be the formal written order by the judge. I don't think it'll be a very long video, but I do like to give orders, especially dispositive orders, not necessarily any other type of order. In fact, most of the other orders I just lump into another video. Anyway, I like to give dispositive orders an actual dedicated video just to themselves because they're so important in a case. Those are going to be what controls the case going forward. Those are permanent orders. And so my mindset at the time was, I don't know, I guess I feel like it's that mixed emotions. I can remember it. Feeling like the Supreme Court cared and feeling like my child custody judge didn't. That's simply how I felt. I felt like I had these two very different perspectives. You know, a series of high judges who looked at all the details of the case and got down into the nitty gritty and paid attention. And this other judge who was just like, stop filing papers. And that's pretty much all he thinks about all the time. And so, I mean, I still had that anxiety and I didn't know what he was going to say in that order. I really liked that he said he would take it under submission, but I wasn't completely convinced that he'd rule in my favor. So, I mean, we're going to go ahead and at this point in time, let's take a look and see what this judge has filed. Here we have the judge's order after hearing regarding motion for order to show cause. I'm not sure if this even has anything on the child support stuff. I think it does, but I'm not sure. The above entitled matter came before the court July 25th for a hearing on order to show cause. He is stating summarily that I was present representing myself, that my ex was present with her attorney, and that he heard testimony on, see, this is key here, guys. This is, he's considered evidence when he's mentioning specifically that he heard testimony. There is a difference between what he heard at that hearing and what he heard at many of the other hearings. Evidentiary hearings and trials are very different from the other types of hearings. They look the same to the average person, but to an attorney and to somebody who's done, some research and dug into it, it's very clear that different things occur in these different types of hearings. And in this hearing, he's stating here that he took testimony. Based on the papers, pleadings, and orders, he's going to order as follows. First assertion is that my ex failed to provide me with the child's homework packet for a total of approximately 6 times over the course of 8 to 10 weeks, as well as declined. Oh wait, guys, hold on a second. Okay, so, at that hearing, I mentioned that I could only prove 4, but I alleged that there were over 6, or approximately 6. And you can see here that even though I told the judge I could only prove 4, he still dinged her on 6. The reason why is because my thought of what proof is different from what the legal system thinks proof is. My thought was I needed emails and some other kind of admission, but the judge knew that my words alone, that my statements to him alone counted as evidence. And so he took my statement that 6 times she failed to provide, or at least he's taking my allegation here. Maybe he makes a different finding of fact further on down, but he could potentially say that he found her to have violated 6 times just based on my testimony alone. He can do that. Going into the next section or the next portion of this paragraph. She declined to cooperate with my suggestions on how she could provide me with the packet in alternative ways. Pursuant to the order filed February 8th, the packet was supposed to travel with the child. She utilized a third party to facilitate exchanges and failed to comply with the court's order. The court found her in contempt of court and sentenced her to 24 hours in jail. Now here, he doesn't distinguish in any way, shape, or form. He doesn't say that he's only going to find 4. So he says I alleged 6, and then he goes straight into his conclusion. So this means we can infer that he dinged her on all 6 violations. So that's really nice. I didn't think that he would do that. Moving on into the next paragraph here. I allege that my ex violated the court order on May 10th by not giving me 14 days notice of a dental appointment. And then this is where if I remember correctly, he states that she was justified in violating the order because it was an urgent need for her son. I talked about this at length in the video, but he should be denying this one. Scrolling down a little bit. Therefore, okay, so yeah, he's saying it's not feasible for her to provide 14 days notice because of the urgency, and therefore this portion of the order to show cause is denied. Next, he goes into, yeah, so this doesn't have the child support, guys. So the child support stuff must be coming later. In any event, let's continue. Motion for order to show cause filed on June 19th, requesting an alternative for communication between us in the event of an emergency regarding the child. The court grants this request in the event of an emergency regarding our child. My ex is to notify me via text message, and I am to notify her via a third party. I think that's everything for this order. Again, guys, I was warning you it would be a short video, but this is the final written order. We got the certificate of mailing and or electronic service under Rule 5, indicating that he sent this to both my ex's attorney and me. Going on into the next document, just an ancillary filing. It's a return of writ from the sheriff. So these usually will pop in about a month or two later after the sheriff has seized money. So the sheriff here is reporting to the court that he seized my ex's paycheck from the VA hospital and that he took these monies from her paycheck. And he gave these monies to me. I'm the creditor. So this is what I was talking about way earlier in the series, guys. If you want to learn more about execution and asset seizure and how you can seize your ex's assets without using the Child Support Enforcement Division, you can watch that video. I do want to stress to my viewers that this was me doing it myself without the district attorney's office. I did not use the Child Support Enforcement Division. I, on my own, issued the writ, and the sheriff directly sent that check to me. It didn't go to the government and then to my bank account. The check came to me from the sheriff after he seized it from my ex's wages. Going into the aftermath, I didn't file any documents, so I incurred $0 in costs. My ex's attorney didn't file any documents, so she incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees, and my ex's attorney would have probably spent no time at all reading the return of writ, and I think she would have probably spent 15 minutes reading the order after hearing, only because it was so short. It's an important order. It does require being logged in her system. It does require some communication with my ex, and I don't think it's a lot of communication because it's so short, because she kind of knew it was coming, but I do think 15 minutes is reasonable. So under the circumstances, that's going to come to $62.50 in attorney fees for my ex. As with my previous videos, if you have any questions, feel free to post them down in the comments below, and I will see you guys next time.